Affidavit filed by the petitioners, it is seen that notice was served to the respondent's number so and so, okay, on and duly received by the said respondents on 6/01/2026. Then comma 07/01/20 and 07/21 respectively. Okay. Accordingly, notice is deemed to be complete upon the respondent's number so and so. However, none appeared for the respondents. Full stop. Miss.
I'm appearing for two, respondent two.
So and so appears on behalf of respondent number 2. We may await for the respondent's number, same so and so, to be duly represented till the next court date. List on, list after 2 weeks, 3 weeks? List after 3 weeks.
No much.
For orders, item number 12.
Please, Your Worship. Your Worship, I am appearing on behalf of respondent 1, 2, and 3. I may be given 3 weeks' time to file my.
You have not filed your PAR?
Yes.
You're appearing?
Yes.
Are you sure?
Yes. And 3 weeks' time will be granted to file my opposition.
You have not filed your PAR?
Yes. In 3 weeks' time.
Okay.
Lordship.
Mr. So and so, yes.
I'm appearing for respondent number 5 for the first time.
Okay. So you want to file your written objection? What is the IE about?
Delay, Lordship.
How many days?
105 days, Lordship.
Are you going to file your written
If
objection?
necessary, I'll file the
Okay. Mr. So and so, learned counsel for the applicant is present. Then Ms. So and so appears on behalf of respondent number 5, while Mr.
Is that cool?
Zetko appears on behalf of respondents number 1, 2,
And
3, and submits that he will be filing his PAR when?
Within the course of the day.
Within the course of the day, and pray that he may be given time to file his written objection. In view of the above, list the matter after 3 weeks for the respondents to file their written objections, if any.
Much appreciated.
Obliged, Lord.
For orders, item numbers 13 and 14.
Yes.
Lord, I will not take much time in this matter. We are not on the main case. An IA has been filed before this honorable court, IA 2 of 2026. Lordship got it, IA2 of 2026.
Yes.
Please see the order of this court at page 12. I'll just read this order. I'll not.
Sector page 12.
Page, Lordship got it, page 12. IA2 of 2026.
Yes.
Please look into page 12, the order, and please turn to page 13 at paragraph 3. It is submitted by Mr. Das so and so that the case of the present petition was initiated on a transaction of money in the year 2010 is a fax with one Arun Butoria who died in 2011, wherein there was a transaction of 5 crores, and as per the statement made in the FIR, all these transactions were in cash, and the present informant was assured that he would be paid 30% of the profit for the said amount given. The transactions were purely commercial and not a case of simple entrustment of property of money. Rather, it is a commercial transaction where it was promised to pay 30% profit to the present complainant. But from the money received which was given in the letter pad of the complainant, it reveals the entire transaction was taken place in the presence of one Pradeep Agarwal. And in this said letter pad, there is no mention at all about the presence of the petitioner, who is stated to be one of the directors of the company, namely EFCON. But the said Arun Bhutoria was not the director of the said company at the time of transaction of money, and what has been done was purely a personal transaction. Petitioner name was not even present at the time of transaction, but only for procuring money, the name of the present petitioner along with 2 director names is mentioned in the FIR. The entire transaction was completed in the year 2010, but after a long 15 years, the present FIR has been lodged in the year 2025. The learned senior counsel further submitted in the year 2023, that is after 13 years, a GD entry was made, but it was kept in abeyance and some assurance was given from the accused person. Subsequently, the FIR has been registered only in the year 2025. So and so the learned senior counsel submitted that these are all oral submission from the informant, but there is no documentary evidence except the money received to substantiate the plea of complainant. Transaction was completed in presence of the petitioner, who is one of the director of the company, namely EFCON. Further, it is submitted that as per one notice under section 35(3) of BNSS was stated to be issued on 14/10/2025, directing the present petitioner to appear before the IO on 31/10/2025, but the present petitioner never received the notice under section 35(3) BNS and is presently in the US after the miscarriage of his daughter, and since August 2025 he is in the US, but without even receiving the notice, an order of issuance of NBW was procured by the IO, and subsequently by an order dated 2/12/2025, learned magistrate has withdrawn that NBW which was issued earlier against the present petitioner. Further, citing the judgment of the Honorable Supreme Court in so and so, it is submitted there is no ingredient to attract neither section 406 nor 409 as registered against the present petitioner, and the law clearly recognizes the difference between simple payment, investment of money, and entrustment of money or property. But here in the instant case, as it is seen from FIR itself, that it was purely a commercial transaction wherein the informant was assured to be given 30% profit by the late Arun Bhutoria. Thus, there cannot be any case against the present petitioner under section so and so. However, it is submitted the present petitioner is still ready to cooperate with the IO in compliance with section 35(3), and he may be interviewed virtually as he is presently staying in US. Further submitted that no coercive action may be taken against the present petitioner, is ready to extend his cooperation. Now, my learned friend, the learned public prosecutor, Nagaland case is still under investigation and is presently required for his notice under section 35(3) BNSS has already been issued against the present petitioner. But despite of the notice issued the petitioner, he is not cooperating with the IO and his physical presence may be required for the interest of the investigation. Considering the entire submission made by learned counsel of both sides, on perusing the case record along with the annexure and petition, IO is hereby directed not to take any coercive action against the petitioner. However, the accused petitioner is directed to extend his cooperation with the IO of this case. However, till return from US, he may be interrogated or his statement may be recorded by IO through virtual mode. However, the investigating officer will also make inquiry in compliance with section 35(3) of BNS after his physical presence before the IO, preferably within the first week of February. Issue notice so and so, in the meantime so and so. So this was the order that was passed. Now I have been protected by this court. Now thereafter we file an IA. We file this IA after this order showing one judgment of the Supreme Court, and we said that my statement, even after the court passed an order, my statement was not recorded. And two of the emails were sent, which is at page 17 and page 19. Page 17 and page 19, these are the emails after the order that has been passed. Now, this matter was heard by this Honorable Court on this IA. An order was passed. Please look into order of 19/1/2026. My Lord,
Yes.
please see the last order passed by this court on the IA. Now, if your Lordship kindly see para 2, by order it had passed in criminal petition, IO, Lordship got it? IO was directed not to take coercive action against the appellant. Applicant petitioner was further directed to extend his cooperation from the IO in this case till his return from the US. He was allowed to interrogate it or have his statement recorded by the IO through virtual mode. It was, however, provided IO could also conduct an inquiry in compliance with section 35(3) of BNSS after the applicant's physical presence before the IO within the first week of February. Learned senior counsel submits that the applicant has communicated by email dated 16/12/2025 to the officer in charge Suburban Police Station, Dimapur, requesting that his statement to be recorded through virtual mode as directed by the order dated 10/12/2025 in criminal. However, no reply was received from the police authorities. Applicant again on 9/1 sent a follow-up email requesting the same. Till the date of filing of the instant application, no response has been received from the police authority. By filing this IA, the applicant seeks direction for compliance with the order dated 10/12/2025 passed by this court in criminal petition number and or dispensation of notice under section 35(3) of BNSS. Applicant also prays for modification of para 9 of the said order to the extent that his statement may be recorded first by virtual mode and till then his physical presence before the IO as directed by this court be kept in abeyance. In this regard, learned PP fairly submitted he has no objection provided the applicant furnishes his present contact details with alternate contact number to the IO for recording his statement virtually. At this, in addition to the earlier contact details already provided, that's the address number so and so, learned senior counsel provided the alternate number of the applicant. In view of the above submission made by parties, the prayer of the applicant is allowed. According, IO shall first record the statement of the applicant to virtual mode. Till 10, physical appearance of the applicant before the IO directed earlier by this court in paragraph 9 shall be kept in abeyance. Now, I have been told by my client that yesterday my statement has been recorded through WhatsApp mode. Not maybe virtual, but through WhatsApp mode, they have recorded my statement. In pursuant, this order was passed in pursuant to a judgment of the Honorable Supreme Court where I placed before the court. In that judgment, my lord, what has happened in Supreme Court exactly is a same case. It's a case where 482 for questioning of an FIR. Then there was at one stage, my lord, what has happened? The High Court, Supreme Court has passed an order. It went to Supreme Court against the order because her presence, High Court, her presence is required.
Okay.
We went to Supreme Court. Supreme Court said yes, they have gone for questioning. There is already an order not to take coercive measure. In the meantime, virtually, my lord, the statement can be recorded. So, if virtually the statement is recorded, so physical appearance may not be required till disposal of the 482 application.
Yes.
So, my learned friend, I have cooperated with the investigation IO. My submission before this court is two lines. One is that this IA might
IA
not
can be disposed of?
Yes, correct. And on the ground that physical my appearance may not be required because and today I am telling on behalf of my client, if at all you are required, anytime I will be there, they can do WhatsApp or virtual mode. Because I am till today I am in US because of mishap which has happened to my daughter. Because a still baby born, my lord, the
Yes,
birth was given
okay,
only on this ground. So I think, my lord, this IA,
I think this can be disposed of,
this was
no? The IA,
Lordship, since this
Yes.
is
the
the instruction that
status
I
report, I
received.
think.
okay, so it's taken, so we will dispose of the instant
IO
IA.
and my presence may not be required, my lord. Physical
Yes,
presence at this stage, till disposal of the criminal petition, my lord. Hear it, my lord. Today, if your lordship finds no case has been made out, and your lordship will record the statement of my client also, my lord, on behalf.
So this is a status report, what does it say? That it has been recorded?
Lordship,
Okay, so we will dispose of the IA,
Lordship,
okay, that physical this thing presence is not required at this stage
Lord.
since it has been recorded.
Yes.
Okay, I'll pass the order
Lord.
accordingly. Now, in the main criminal petition,
Yes, there is already interim order which I am protected. That will continue, my lord. Not to take any course.
now, who is responded number 2?
I think once he appeared, no, but there was no wakalatnama.
Huh.
There was
So
no.
your parties are not all present, so this will fix another date.
Yes,
isn't
yes,
it?
correct.
Meanwhile, interim order, okay.
Why I'm saying, my interim order not to my lord Kohima, no problem, it's there. So that can be extended.
Oh.
And in the meantime, IA can be disposed of saying my physical appearance is not required.
yes.
Third, my lord, I will pray on the next date, a date for hearing my IA, another for stay of that investigation. That on the next date.
But won't it better for you if the investigation, your presence is not required?
Yes.
If the investigation continues and ultimately maybe this criminal petition itself might become infructuous if no case is found against you?
No.
What is going on?
No. That's what I am saying.
Uh-huh.
Because
After
because-
the, no,
no,
after the
what is there?
investigation, they
No,
could pray for your
investigation-
discharge also if you're so sure that you're not involved.
No, what I'm saying, 100%, my lord, I have shown to the court, my lord, just putting up for example, 5 crores in cash. And how, my lord, a person, he is dead. 2010, a money was given to buy informant to Pradeep, to one Arun Bhatoria. In 2010, 2011 he died.
Anyways,
So,
that we'll have to see.
No,
the
that's what
grievance.
I'm saying, yes.
Oh,
Your-
let that
Yes, your
this
lordship
thing
will
come
pass
up.
this order and keep on next
Then
date.
the
Yes.
next IA we'll see.
We'll
You
see.
Because it
IA
might
can be disposed of. This IA
This
is-
IA is disposed of. Concerning filing of another IA, that's a different matter.
No,
That
IA
we'll
will
see.
not, yes. We'll
That
see it.
We'll see,
Yeah,
yes.
that we'll
Anyways,
see, yes.
on the disposal of IA number 2/2026, heard Mr. Didas, learned senior counsel, assisted by Mr. Idas, learned counsel for the appellate. Full stop. Also heard Mr. We learned public prosecutor for the state respondents. However, it is seen that none appeared for respondent number 2. In view of the above, list the matter again. When do you want it?
On 9th can be 9th, my lord.
Okay.
This 9th, because I'll press for that, your lordship press for that interim order. 9th is
Okay.
Monday.
Okay, in view
That
of the
becomes
above,
easier.
list on 9th,
February.
09/02/2026. Meanwhile, interim order passed earlier shall continue till the next date of listing.
And my my lord, IA can be disposed of.
No, I've
This
already, yes, I'll pass the order later, dispose, so I've mentioned
Your
on the
lordship will pass
disposal
later
of.
Yes, oh, okay.
I will
fine.
pass the order, so in today's order, in the criminal petition, I've mentioned on the disposal of IA so and
Yes,
so.
but this is, my lord, my interim order will continue.
So interim
In this-
order
this
passed
will
earlier.
continue in
Yes,
the
yes,
main case.
Shall continue till the next date of listing.
Yes. And IA, my lord, I have prayed, your lordship, is that it can be disposed of by the direction that no physical
Yes, yes.
appearance is not required.
Not required.
Yeah, I am deeply obliged.
Pass
my
the
lord.
full order
Yeah,
later.
I am deeply obliged, madam, deeply obliged.
For orders, item number 16.
May I please, Your Lordship? Lordship, as per, in the last occasion, this honorable court has, in the order dated 7/11/25, this honorable court has directed me to file a petitions, amended ghost title, Your Lordship, in
So
connection
you
to
have
civil revisions.
amended?
Yes, Your Lordship. And the record is,
So what is the IA about? IA is disposed of. There's an IA here. IA is not required.
No, this IA then of 2026 is it is an amended ghost title petition. I've been directed by this honorable court, Your Lordship. If
So you have directed, so it's, application stands disposed of, so IA is disposed of.
Yes, actually, Your Lordship, in connection to this matter, I filed two IA. The first IA, Your Lordship, is for the deletions of the respondent 3 and 4. And again, in the last occasions, 7, 11,
So has
25.
prayed for deletion of 3 and 4.
Yes, Your
Okay,
Lordship.
so it's prayed that. So to file a new amended cost title, already allowed. So file a new amended cost title. What's the IA for?
Actually, I reflected in my affidavit for the records, Your Lordship.
For?
For the records, Your Lordship. For the records, Your Lordship.
For the records.
Yes, Your Lordship.
Praying for amend. So, see, your IA is, let me see what, I'm not understanding, let me see, newly amended title resolution. So now, your IA is for amendment of the cost title, isn't
Yes,
it?
Your Lordship, for
But this
amendment of the cost
court, in its order dated 07/11/2025, if you read the last para, it has the last line, second last, it says the applicant shall take steps to file a new amended cost title in criminal revision, already granted. Okay, so we'll dispose of the IA on those grounds.
Yes,
Okay?
Your Honor.
Heard Mr. So-and-so, learned counsel for the applicant, who has filed the instant interlocutory application for amendment of the cost title in the connected criminal revision number 07/2025, which was allowed, okay.
Civil revision.
Your
Civil.
civil revision.
Okay, civil revision,
7 of
yes,
2025.
7 of 2025. By submitting that, he was allowed to strike off the name, he was allowed the deletion of the names of respondents number 3 and 4 in the civil revision, full stop. This court, on perusal of the order of this court dated 07/11/2025, finds that this court in the said order had already directed that the applicant shall take steps to file a new amended cost title in civil revision 7/2025. Full stop. In view of the above, since the prayer made by the applicant in the present interlocutory application has been already taken care of, the said IA number 10 of 2026 stands allowed and disposed of.
Your Lordship, then if I may place some submissions in civil revision 7 of 2025, that is the main petitions, Your Lordship.
No, so now,
Your
you have to
Lordship.
take steps for amendment of the cost title.
Yes, Your Lordship. However, in the 7/11/2025, I was being directed to serve a notice to respondent number 1, which I've already duly.
Okay,
Yes, Your Lordship.
respondent number 1.
Yes, Your Lordship.
Lordship, in this case, I am applying for respondent number 2. I am yet to file my affidavit. I may be
Affidavit.
given 3 weeks' time.
Okay, fine. We'll give you that, but then now you have to take steps in the cost title.
Yes, Your Lordship, I'll
Okay.
do that.
So, and you have to serve notice to respondent number 1.
Which I've already served, Your Lordship,
Ah,
through
but-
one of the messengers, Your Lordship.
And that will see, served or not, through the, it has to be done through the registry, and the registrar has to make a note, okay, whether notice upon respondent number 1 is complete or not. Have you done that?
Yes, Your Lordship. Actually, as far as concerned to the notice, to the respondent number 1, I've served
Affidavit with
in
regard
2
to
occasions. Your Lordship.
her, number 1, not filed, affidavit with regard, on behalf. So, respondent number 1, you have to file an affidavit, have you filed that?
Actually, Your Lordship, if I may place some submissions here, Your Lordship, the notice has been served through one of the messenger that hold the same petitioner's village, Your Lordship. However, the respondent number 1 refused to give back the court copies, which I'll be placing before Your Lordship.
So place that before. Okay, right now we cannot say it has been served because we have to wait for that whatever affidavit, whatever you have to make, okay, that notice.
Yes, Your Lordship. I've also made a communications with the respondent number 1 regarding to the records. However, I've been informed by the respondent number 1 that the gold copies will be served through his counsel, Your Lordship. That was a communication that I've
Anyway,
been
so that's a submission, you make it in form of an affidavit, because here, this court's order says that you have to take steps for service of notice through dusty mode, okay? So if you cannot do that, you file an affidavit saying that whatever submissions you've made today, okay?
Your Lordship.
Okay, then in the main civil revision, okay, Mr. So-and-so, learned counsel for the petitioner is present and submits that he will be taking necessary steps for amendment of the cause title on the disposal of IA number 10 of 2026, full stop. The learned counsel also submits that he will be filing an affidavit with regards to service of notice upon respondent number 1.
Yes, Your Lordship.
Then, Mr. So-and-so, learned counsel for respondent number 2 is present and submits that he needs 3 weeks' time to file his affidavit in opposition. In view of the above, list the matter after 3 weeks.
Your Lordship. Obliged, Your Lordship.
May I please, Your Lordship? Your Lordship, my DC link was removed for some time, so I wasn't present when item number 4 was called. I'm appearing on behalf of the respondent.
Okay, item number 4, respondent number what?
I'm the sole respondent.
All the respondents? Is
I'm
there
respondent
number?
number 1,
Okay, then in item number 4, the presence of Miss
F.
So-and-so
Ahmed.
appearing on behalf of respondent number so-and-so, through VC is noted. Respondent number 1, you said, isn't it?
Yes, Your Lordship.
Is noted. Yes.
I seek some time to file my objection.
I think we have made an order for the next court date to file a written objection, if any.
Obliged, Your Lordship.
Done? Okay.